So hello everyone, welcome to the Big Tent briefing on digital trade rules. My name is Arthur Stamoulis. I'll be moderating today's discussion. Most of you know me as the Executive Director of Citizens Trade Campaign, which is the US coalition of labor, environmental, family farm, faith, and consumer organizations that works together to improve US trade policy. I'm still very much in CTC, but I'm also the director of a brand new organization called the Trade Justice Education Fund, which was founded both to do more back to basics, grassroots public education about what we want in trade, and also to keep an eye on emerging issues in trade policy, like the digital trade issues that we're going to be talking about today. This is one of the first events that the Trade Justice Education Fund is publicly co-sponsoring, and really appreciate you all being a part of this. Before I introduce today's presenters, let me just say from the outset, our broad network of organizations has a ton of expertise on a really wide variety of public policy areas that are affected by free trade agreements. We know all about investment rules and labor rights and environmental standards and agriculture policy and procurement and intellectual property and just a host of other trade issues. But this area of digital trade rules is one that certainly I know much less about than those other areas. And so I'm really excited to learn more about it today because trade rules affecting the digital economy have fast become one of the top priorities for corporate lobbyists pushing new trade agreements. The line on e-commerce and digital trade chapters and pending trade deals is often, oh, these are just about helping small and medium-sized businesses reach more customers through the internet. There's nothing really to see here, move along. But in reality, we know it's not mom and pop businesses that are going to the US Trade Representative demanding digital chapters in the UK FTA, the Kenya FTA, other trade negotiations. Instead it's some of the biggest corporations on the planet that are pushing these rules. Amazon, Google, Facebook. And as we're going to hear, these rules have really profound implications on our organization's members in terms of jobs, in terms of racial justice, and in terms of consumer rights. So to discuss these issues, we're very, very lucky to be joined by three people who've been looking at different elements of this very closely. Duncan McCann is senior researcher at the New Economics Foundation, a British think tank that promotes social, economic, and environmental justice. I first heard of Duncan after reading the excellent paper he wrote for the International Trade Union Confederation on free trade agreements, digital chapters, and the impact on labor. Duncan's going to be speaking to us about how digital trade rules can affect outsourcing, labor rights, expansion of the gig economy. Then we're going to hear from Amba Kok. Amba is Director of Global Strategy and Programs at AI Now Institute. And is also a fellow at NYU Law's Engelberg Center. She's very graciously joining us trade geeks to give us some, 101 level background on algorithms, the existing and potential biases within them, and why we should be concerned about algorithm transparency. And then to connect the dots back to recent and pending trade deals, we're going to hear from Burju Killick-Seitz. Many of you remember Burju from the wonderful briefings on access to medicine during recent trade negotiations. Well, she is now the Director of Public Citizens Digital Rights Program, and she's going to be sharing with us how digital trade rules undermine consumer privacy, corporate accountability, and related issues. So each of our presenters will speak for about 10 minutes. If folks start going over, I may interrupt, because we definitely want to leave plenty of time at the end for your questions and comments. And I think we all know the drill on Zoom these days, but if you do have a question as we go along, you don't have to remember it until the very end. Please go ahead and hit the Q&A button at the bottom of your screen. You may need to roll your cursor or your finger over it, depending what you're using to log in. But go to that Q&A button and write your question for the panelists there at any time. And we will get to as many questions as we can in the hour that we have together. And with that said, let me thank you all again for being here. Thanks especially to our panelists. And Duncan, let me turn it over to you, please, to get us started.
Brilliant. Thanks so much, Arthur, for having me, and thanks everyone for joining today. So I'm going to try and cover off a little bit of giving some kind of high-level talking points about the digital trade chapters themselves, and then dive into a few kind of specifics around where they may start to really have some really meaningful impacts on labour markets and jobs more generally. So it's a complex topic. It's always hard to summarize. So I do encourage you to read, the longish report that I wrote for the ITUC. I'll make sure to include a link in the window for those who need it. But I think what I want to start with is just.
If I can interrupt for 1 second, are we on speaker view or gallery view now?
I can still see all four of us.
Okay, let me switch back. Perfect.
See, yeah, it hasn't really changed on my view, but
okay. Apologies for interrupting. Go ahead.
That's all right. So what I wanted to start with is 4 kind of overall points that I want to make about the digital chapter more generally. So the first one is for those who aren't familiar with the contents of digital chapters. They cover a broad range of things, from the relatively uncontroversial, things like elimination of spam, which I think we could all agree is probably a good thing, to things that really do enable the basics of e-commerce, things like cross-border authentication, digital signatures. Ultimately, we do want a digital economy where, a carpet maker at Vietnam can sell into the UK or the US markets and vice versa without, a huge amount of hassle. But these relatively uncontroversial topics are then mixed in with others which are hugely controversial. So things like source code, which Amber will talk about later, things like maintaining kind of free cross-border data flows of data, prohibiting data localization, minimizing the ability of governments to have real data protection for personal data. And so, as I look through these provisions that are contained in the kind of the traditional digital trade chapter, what's clear is that most of these are really not specifically trade issues. And so our first, and it may not be a politically feasible achievement, but really these are inappropriate for inclusions in free trade agreements. And really our default position in arguing against many of these should be that these are not well made for either bilateral or multilateral trade agreements, and really we want to regulate this domestically. And certainly the source code and algorithm example that we'll learn through later today is a really graphic example of that. We need local democratic control over that. The second point then is really that although these digital chapters in some ways look like rules that we have to follow, I like to think of them much more as kind of anti-rules. Because their design is not to create a specific regulatory environment in which the digital economy can grow in a safe way, but they are really designed to limit the ability of domestic governments to regulate. This is particularly worrying in an area like the digital economy, because really the digital economy is still just emerging. It's still relatively nascent. It's still growing. It's still evolving as we speak. And so locking the ability of governments and what they can regulate is hugely damaging at this point in the growth of the digital economy. The third really key point, and again, it will probably translate across the other speakers as well, is that digital technologies are already impacting and disrupting our economy, our jobs, irrespective of whether they were going to be included in international trade agreements. But what these trade agreements do and their purpose and why they're being pushed, as Arthur said, by big companies, by tech lobbyists, but why we see them as a risk is that actually they're going to embed this low regulation environment. And for us, for my organization as a kind of a civil society organization, for unions and others, they really exacerbate the existing adverse risks, both socially and economically, that arise from this current kind of digital disruption. And again, by locking in that liberal, under-regulated environment. The fourth kind of general observation before I get into some of the detail, and just because I think it's really, really important, it can seem like the digital trade chapter is a kind of small little niche chapter that's been put on. And yes, okay, it affects some big companies, obviously the Alphabets, the Amazons, the Facebooks and the like. But I think there's a wider point, and and I'm sure it will come out when the other speakers as well, is that really the digital, the companies underpinned by data and algorithms are really becoming ever more central components of our social and economic lives. And as the reach of data and digital and everything that underpins them grows, actually these digital trade provisions are actually going to start to have impacts in sectors that we would not normally associate with the digital transition. And so, for instance, in the report that Arthur referenced at the beginning, I give a long explanation of how the digital trade provisions might start to impact the agricultural sector through a whole variety of mechanisms. So I think it's really important that as the digital economy grows and as that spreads out, the impact and the importance of these digital trade provisions will also grow. So those are kind of my general observations. And I now want to just focus in a little bit on some of the specifics of how these chapters may impact the world of work. So the first kind of point is that I think that the implementation of these chapters would ultimately lead to an increase in precarious work. We can call it gig economy work, however we want to term it. Now, again, this is a really good example where it's clearly not the digital chapter that either invented precarious work, the gig economy, or the companies that are really pushing this particular model of employment. But again, they do seek to favour it and the companies that push it, which is the real key. So, and again, it's really interesting here. The tech giants offer, although they obviously have created some highly skilled jobs, engineers, coders, product designers. In fact, when you look across our kind of digital economy superstars, the majority of the new jobs that they create are precarious and low skilled. You can think of Amazon and their warehouse workers. You could think of Uber and their drivers. You could think of Amazon Mechanical Turk and the Turkers doing kind of data entry and other things. And the real key to the success of many of these platforms is the huge amount of data that they're able to collect and process, together often with an ambition to kind of automate the market. And so you hear a lot about, Uber's obviously collecting the data of their drivers as they go, with the ultimate goal of having obviously a fleet of driverless vehicles and the workers being a kind of painful interim step for the company. Rather than something they need to, rather than people they need to care about for the long term. And as this platform work has proliferated, what's also happened is that collective bargaining has been especially curtailed, since this is much harder for the self-employed, at least definitely in the UK. I imagine the US faces similar challenges in this area. And so what you get then is a combination that the majority of the digital trade provisions, so including things like the prohibition on data localization or making servers local, the requirement that source code secrecy, the free cross-border data flows, and even things like the attempt to abolish kind of net neutrality. All these kind of provisions favor the largest transnational tech companies because they ultimately are able to exploit the opportunities of scale, benefit most from keeping things like source code secret, are best able to exploit global data flows and the like. And so all of this preference for these large tech companies, along with the generally perceived trend that these tech companies, the work that they tend to create tends to be precarious, gig economy kind of work. So all of these provisions favor the companies that are most likely to make this happen. And ultimately, this makes it much harder for local and especially non-digital alternatives to survive and emerge, especially ones with kind of social or environmental considerations. And I know this partly firsthand. I spent a year working with Uber drivers here in London to try and create a worker-owned alternative. And again, although some of these provisions would have hit us once we became live, there were many other issues that made it a challenge to get started. but this is definitely would have been a major challenge for us as a relatively small, locally embedded alternative to such a large multinational, transnational company. So these provisions, by the nature of them benefiting kind of the tech giants, should lead then, and expanding into other areas, should lead to a kind of an increase in precarious work and platformatized work. Another interesting and worrying implication of some of these digital trade provisions could be that make it much more hard to both win new workplace rights around data and surveillance, and potentially also lose some other areas. And so many trade provisions, when you just read them as a layperson, actually contain what seem like really generous exemptions that allow governments to regulate in the area that would otherwise be prohibited. They generally term it that, a party may, in the pursuit of a legitimate public policy objective, counter some of the provisions in these trade agreements. And so to the layperson, that seems like a big amount of leeway that governments have. But in fact, when you look into actually how these, actually what is a legitimate public policy interest as defined by the agreements, you find they're relatively restrictive. And they also place this idea, this necessity test on governments who wish to use it, which is that the restriction must be no more restrictive than necessary. And this combination of requiring some legitimate public policy, as well as it being no more restrictive than necessary, has meant that governments have almost always failed to use this particular exemption. And in fact, only 1 of 45 challenges have been successful. And a colleague of mine here in the US, Laura Bannister, who works for the trade justice movement, really put a really graphic example at a recent WTO public forum, which I wanted to share as an illustration about how some of the challenges we might face with these kind of provisions. And so as the audience, as many people will know, many gig economy workers are already under heavy surveillance. And this is not only this is also expanding outside of working hours. And workers and trade unions are starting to effectively demand an end to this excessive digital surveillance, as well as, things like new digital rights for workers. Now, should we be successful in those demands in the future, and government decide to enact policy that either banned or severely curtailed the ability of companies to collect data on workers, which we would deem excessive surveillance, it could easily be considered more restrictive than necessary by a trade court and wiped out. And this is because tech companies would be able to easily demonstrate its impact of these measures on trade, so that it did have a real impact. But we as unions and workers may actually struggle to provide the scientific counter-argument that shows that the data gathering was either damaging to workers' well-being or to their privacy or something else. And so that's just one example, but we could think of other examples that are similar. So I know that I'm already over. It's always really hard to cover these topics in 10 minutes. I'll just mention very briefly one additional potential impact, which is that these trade agreements will also maybe make it harder for us to enforce local laws, labor laws amongst them, against some of these companies. And that's because the provisions provide for any provider of service to not necessarily have to have a local legal presence. And so the ITUC, who I did that previous report for, has noted that without a local presence of companies, there is no entity to sue. And so the ability of domestic courts to enforce labor standards as well as other rights is really fundamentally challenged. And then if we think of how these tech companies, think of Uber and the like to think of themselves actually as service companies, imagine the challenge we would have faced, taking Uber and making Uber accountable is already a challenge even when they're based domestically. And so we're facing challenges like that in the UK and happening in many places in the US. Imagine if Uber had taken advantage of this and had no local legal entity for us to enforce against. And in fact, the only representative of the company were in fact the self-employed drivers driving. How would we start to maintain and try and enforce some of these labor laws that are so important, obviously? So So a bit of a whirlwind. Again, sorry for going over. Really looking forward to questions after this. Do urge you to read the report if you do have the time. And yeah, you can find my email and on the New Economics Foundation website, or else I can share it. But thank you very much for listening.
Yeah, thank you very much, Duncan. Let me turn it now to Amba from the AI Now Institute to give us a little background on algorithms and why transparency matters.
Sure, thank you, Arthur. So maybe to begin really quickly, Arthur mentioned I'm from the AI Now Institute. We are a research institute based at NYU, but we conduct both research and advocacy on the kind of social and political implications of AI. And our kind of goal or vision is that these technologies are only used in ways that are just, equitable, and accountable. So as my role as a head of global policy and programs is to kind of orient our work more globally, but also to create more resources that would be helpful, particularly to this community of digital trade activists and unions. So just at the front, I wanted to say that please feel free to reach out if you have ideas for what might be those kinds of resources and what would be helpful. Today, I'm going to sort of focus my comments, as Arthur mentioned, on unpacking the main concerns with AI and algorithms. These are quickly becoming the focus of regulation, in many parts of the world, but particularly so in the US and in the European Union. And this has come from a recognition that existing data privacy laws, which do exist, kind of don't do the job or don't really capture the nature of harm that we're seeing come out of these technologies. And my comments today are focused on the context of the US, but my own work and expertise is more global. So if folks have questions on the rest of the world, I'm happy to get into that during questions. So even if you haven't been following this space, I could probably guess that most of you have heard of this kind of black box problem of AI, which was a really popular frame in media narratives about these systems. And the dominant idea was that AI systems are somewhat kind of inherently opaque at this technical level, which means that the way in which these algorithms work make their logic very difficult to identify and definitely even impossible to explain. And this narrative also ended up fueling the kind of mystical or magical qualities of AI in public discourse. So the idea that AI can manage high volumes of data and make predictions and find patterns that humans cannot, and humans cannot even comprehend, and therefore they are better or more efficient. But I would say, just as recently as in the last 5 years, and particularly so in the last 2 years, we've had research and advocacy that has demonstrated that this sort of claim of technical opacity is not inherent, but is in fact created and sustained through legal mechanisms. But those legal mechanisms can be overcome. And more importantly, that there are kind of broader structural factors that contribute, both kind of political factors that contribute to why these systems have not been accountable to the public and the communities on which they are used. So often, and just again, this is in the vein of understanding that people throw around the term AI to refer to a whole bunch of things, and sometimes it's like, what are we even talking about? I think people in our field have moved from using the term AI to using a term called ADS, or automated decision systems. And the reason that we've tried to make this tactical shift is that the best way to explain AI, in my mind, and I know that many in this field agree, is as a tool or a software or a system that is designed to automate and replace, to automate, I would say, aid or replace human decision making. So the final objective could be, generating lists, generating scores, generating predictions, classifications. That will change, but eventually these outcomes are all used to either make decisions or aid decisions that can really impact human welfare and a range of rights. Now, again, like I said, when we think of them as these decision systems, then it's easier to make sense of the heterogeneous kind of use cases that fall under the umbrella of AI. So predictive policing, which is what I will focus on today. There is facial recognition, which many of you would have heard of. There's welfare systems that determine who is deserving of welfare, who is should be labeled as potentially fraudulently claiming welfare. You have credit risk systems, which have been around for a while now. You have emotion or personality prediction systems that are being used in job interviews to determine fit. Duncan mentioned AI being used in the workplace. There are now systems that try to predict worker productivity as well as evaluate worker performance. The list goes on. It's healthcare. There's also education. So like I said, the use cases are endless, but I will focus on policing and the criminal justice system, because I think in some ways there is a template and a thread that runs through all of the systems I mentioned. And I'll end with an example from the welfare system in the US as well. Now, in the context of the Black Lives Matters protests over the last few weeks and months, there were headlines that read, "Predictive policing is racist. Facial recognition is racist, and like American policing, it must go." And it was in the spirit of kind of naming the problem with the American prison industrial complex that there was also a window to highlight the complicity of these technologies with these broader systemic issues. And for me, as I read these headlines, it's really hard to overstate, the realization of how far along this conversation has come, because just 5 years ago, the whole claim was that these AI tools will in fact remove racial bias at a time when there was a growing crisis of legitimacy for the American criminal justice system. And that was kind of responded to by saying, no, we're going to bring in these tools and they're going to remove the bias. I'll say this before getting into how these systems work, that even in the current moment, you're hearing a lot of calls for defunding the police, but the subtext of a lot of that, and activists have called this out, is that, the police has already been defunded for many years now, because what's happening is that cities are going broke and they're replacing cops and police with algorithms. So budget cuts means more algorithms for policing. And so I would say that in the current moment, the scrutiny required is probably more than ever. So what is, I've used the term predictive policing there are many kinds, and the iterations grow from year to year, but I'll give the two main types, which is location-based predictive policing and person-based policing systems. Now, with location-based, it's basically you have software algorithms that are drawing on the links between places and events and historical crime rates to predict where and when crimes are most likely to happen. So one of the most common tools, called PredPol, refers to themselves as a kind of crime weather forecast. So by and large, these systems in the US, but also in other parts of the world, are being trained on arrest data, and in some cases on locations from which a call to the police have been made. And I use this term trained on. It's kind of a term of art, but it means how does the system learn what connections are relevant and what aren't, and it is based on that learning that it therefore predicts where crimes will happen in the future. Now, arrest data, as we know in this country, but also everywhere, is kind of deeply skewed and is kind of embedded with racial bias, right? So you're more than twice as likely to be arrested in this country if you are Black than you are white. A Black person is, I think 5 times as likely to be stopped without a just cause as a white person. Now imagine that all of this arrest data with these encoded patterns is then encoded into these systems. As a result, what you're going to have is a system that is much more likely to predict a high potential for crime in minority neighborhoods or against minority people. So I would say that, even where, firstly, all arrests don't lead to convictions, but even where arrest and crime data do match up, there are kind of a range of socioeconomic reasons why certain demographic groups and certain neighborhoods have higher historical crime rates than others. And I'll kind of sum it up by saying what we're doing with these AI systems is that we're basically allowing the past to kind of shape the future, because we know that over-policed and over-surveilled areas will lead to more arrests and more people incarcerated. And that's what we call the kind of dangerous feedback loop of AI. The other kind, and I won't go into this in too much detail, the other kind of predictive policing tool are the person-based tools. So here you're trying to assess a particular individual's potential for recidivism in the future. So, and that will be used, that's sometimes used to inform pre-trial decisions, such as, deferred adjudication or bail or later sentencing. And these systems draw on data about people, like their age, their address, their gender, their marital status, history of substance abuse, criminal record, again, to predict who has a high chance of being involved in future criminal activity. And these tools have been used and are being used by police to sometimes intervene before a crime takes place. So, straight up knocking on people's door to say that they are on watch lists, or by courts to determine during pre-trial hearings whether someone who has been arrested is likely to reoffend. Here too, in 2016, and there have been several investigations since, one of the most popular tools, it was called Compass, COMPAS. ProPublica, the media organization, actually investigated and found that this Compass discriminates against people of color because the algorithm had a much higher false positive rate for Blacks than for whites, and later for Hispanics as well compared to whites. So in other words, the system predicts that Black defendants pose a higher risk of recidivism than they actually end up doing, and the reverse for white defendants who get the benefit of the doubt of these systems. So, I mean, and we're seeing a similar pattern, like I said, with facial recognition systems. It's not also, I think sometimes we get lost in the data feedback loop is just one issue, but the other issue is it's always a question of power. So we're seeing that facial recognition is being used by the police. The police globally is the largest customer of these systems. And they are now, in the last 6 months, facial recognition has been used in Detroit, in Baltimore, in Delhi, in India, in Hong Kong, in London, to identify peaceful protesters and create watch lists. This has led to calls for bans on live facial recognition. And in the US, we've actually had several bans already on police use of these technologies. Here too, there's one argument which says these systems have poor accuracy against people of color, and that has been demonstrated. But the other argument is that even if these systems were 100% accurate, they would still be weaponized against communities of color, against working people and the poor. And so they need to be interrogated not just on technical parameters, but as well as on their political implications. And then I don't know how much time I have left, but let me just end with a non-policing. Are we up?
You can take one more minute. Yeah.
Okay, maybe I'll just end with a final example from the welfare system. This is a case from Michigan where the former governor, Rick Snyder, decided to install this automated decision system called MIDAS. And it was designed to automatically flag workers that were suspected of benefits fraud. Now, they wanted to cut costs, and so the state fired its entire fraud detection division. It turns out that MIDAS wrongly flagged fraudulent activity 93% of the time. The impact of this was that 40,000 Michigan residents were falsely accused of fraud. Their tax refunds were withheld. There were bankruptcies and even suicides as a result of this. And eventually, through an elongated court process that is still continuing, it was discovered that the system was actually riddled with errors. And so to me, I'll just end by saying, for us, it's always the question is never about technology. It's about what is this technology trying to disguise. It could be racist policing policies. It could be austerity measures. And eventually these systems end up scapegoating poor people of color and working class people. Again, and Burju will talk more about this, they are protected by an entire legal regime of trade secrecy and intellectual property that makes it difficult to find out how these systems are working and who they are working against.
Thank you very much, Amma. That was an extremely useful background and overview of artificial intelligence and algorithms. And I'm sure we can go much deeper in the Q&A. To connect this to some of the existing and pending trade rules and cover other consumer aspects of these rules, let me hand it over to Brigitte at Public Citizen.
Thank you, Arthur. You see, okay, are we good here? Yeah. Are we good with the presentation?
Yep, we're great.
Okay, great. Thank you very much, Arthur. And thank you, Amba and Duncan, for doing the groundwork. So it's easier for me to focus on the rules, but also the implications for consumers. And I see many familiar names. So hello to old friends and also hello to new friends. So let's start. I mean, speaking of old friends, I need to start with the TPP, Trans-Pacific Partnership Agreement. And we all know each other from the TPP. I met Arthur during the TPP negotiations, and I met many of you during the TPP negotiations. As you would remember, TPP was a 21st century high standard agreement, and we had our own priorities when we were working on the TPP. I was focusing on IP, intellectual property rights, and especially access to medicines, and many of you were doing like great job on ISDS and other chapters, agriculture and labor and many other chapters. But there was one chapter which was very critical and highly crucial for the industry, e-commerce. And I remember back in 2015, 2014, even 2013, like every time I've been to a UN in DC about the TPP, like there were always people talking about like, oh, the e-commerce chapter, that's the 21st century high standard chapter. We never got to see the TPP e-commerce chapter because it was never leaked. So I got to see it when it was released back in like November 2015. And I have an analysis of the TPP e-commerce chapter from that time. And I was like, oh my God, the tech industry, they did so well. Anyway, so we all know the story about the TPP. We worked really hard to kill the TPP, but then Trump took off the office and he got all the credit for killing the TPP. But, you know, it's interesting, you know, there were all this like criticism about the TPP, and he said that like, like the TPP is bad, but then, you know, he signed USMCA and US-Japan trade agreement, in which like all the TPP rules, especially the e-commerce rules, at that time it was called e-commerce, were survived. So when we look at the digital trade rules, I mean, as I mentioned, they were called e-commerce, and then in USMCA, NAFTA 2.0, they became digital trade because the USTR officials decided that it sounds cooler to say digital trade, more like, you know, like 21st century, like. And so these digital trade rules, they were all made in the TPP. It's very interesting because when you look at the e-commerce chapter of the TPP, you can see like many provisions which cover all the aspects of digital economy. And that was the highlight, you know, when we first analyzed the TPP e-commerce chapter, that was our conclusion. This chapter touches every aspect of digital economy. And then in the USMCA, in US-Japan FTA, they both these FTAs built on the TPP, and they included few provisions such as algorithms, platform liability, open government data. And then interestingly, all the TPP countries after US left, they suspended some of the provisions which we worked really hard against, like such as the IP rules, saying that, oh, these are American rules. But they kept the e-commerce chapter. And interestingly, they like it so much that now they keep like signing, like going around the world, signing all these free trade agreements and putting these provisions, made in America provisions, in their own free trade agreements. So these rules cover every aspect of the digital economy. And when you talk to the trade negotiators, and when you tell them that, hey, and you look at these rules, you see that the consumer data is at the core of the e-commerce. Because when we talk about the e-commerce or digital trade, the personal data, it is all about personal data. It's not the non-personal data. I mean, there are discussions related to non-personal data, but the e-commerce chapters or the digital trade chapters, they addresses the barriers, so-called trade barriers for the flow or the circulation of personal data. Because as consumers, we are at the core of the e-commerce chapter, the e-commerce discussions. That's why we should be part of the discussion. That's the line that we've been telling them, because at the end of the day, data, like pioneering all this like economic activity, is our data. Every time we clicked on a web page, we download something, or we send an email, or data is like routinely sent, and thousands and hundreds and thousands of companies, they use that data, and then we have no control over it. So the issue is the data. It's all about the data, and the question is where the data flows. There are one, maybe two destinations for the flow of the data, and most of the data flows to the US. And cross-border data transfers, and I know that many of us are also working on US-EU trade relations, like you will remember TTIP back from like 2014, 2015, and data transfers were a very major discussion. Transatlantic data flows between the EU and the US, because the data flows to the US, and Europeans have all these protections in Europe, but they don't know what happens when the data flows to the US. So they came up with this structure which was called safe harbor. It was invalidated, and then the US and the European Commission came up with a new legal framework which was called Privacy Shield, and it was also invalidated recently 2 weeks ago by the European Court of Justice because of the lack of privacy protections in the US, and also the government surveillance. So like Europeans, they always felt unsafe about their data flowing to the US. And it was hard for us to understand, because our data is here, right? Like, so what's the problem? But then TikTok happened. And I really like this example, and I'm kind of like, upset that like I'm gonna lose my best like case example, how to explain how Europeans feel about their data. And most of us, like if you have a teenage kid, I'm sure you are concerned about his or her usage of TikTok. And one of the concerns when I ask people is like, oh, the data flows to China. And so it's like Chinese government can survey our data, and we don't know what happens to our data. It's the same line. We don't know what happens to our data in the US either. Because when you look at the privacy in the US, there's no comprehensive privacy and data protection. And the government surveillance is there, and there is no proportionality. So the government has access to our data and Europeans' data, but as Americans, we have a better protections compared to Europeans. And then there are no rules how the data is used, processed, stored, shared, and sold. So the problem is the US, because data flows to the US, and they can do whatever they want with that data in the US. And they want to keep the status quo. That's the one line that I can explain the e-commerce chapters or digital trade chapters, preserving the status quo. So speaking of preserving the status quo, there are other provisions too. As I mentioned, like there are more than 20 provisions which covers all the aspects of digital economy. And as Amba very well explained, algorithms and source codes, these are part of the digital trade. They became part of the digital trade discussions because we are talking about artificial intelligence, like it's gonna determine our future. And source code and algorithms are black boxes. There are all these challenges and controversies related to algorithms. And we are trying to build a system for better oversight and better public engagement with how these systems work. But in trade agreements, tech companies are saying that, hey, these are our trade secrets. This is our confidential information. So you need to protect all confidential information from the other competitors, such as the ones in China. That was the reason that provision first introduced to the TPP. It was introduced by Japan as a source code, protection of source code provision. And it really contradicts with what's happening on the ground in terms of artificial intelligence, algorithms, automatic decision making, because like it once again tries to preserve that system and tells like governments and that you can't really ask access to the source code on algorithms. There are exceptions, and they throughout the years they revised the exceptions and they understood the seriousness of issue, but the exceptions are very, very limited. So like when we talk about artificial intelligence and the cross-border trade in artificial intelligence, we should be very contingent on transparency and accountability. Another issue, platform liability, Section 230. Probably you heard about it. President Trump just introduced an executive orders about Section 230. Section 230 created the internet, and it provides a shield to tech companies from the third-party generated content. It had really good intentions when it was first introduced, but then throughout the years, the tech companies started to use as a shield from every kind of like liability. Like if you're an Amazon and if you are selling third-party goods on your website, you can claim that, you know, these fake products, I have no liability because of Section 230. So it became controversial from the consumer's point of view because of platform liability, product liability issues. And then we have all this like competition and antitrust discussions going on. So it is very controversial in the US. But the USTR introduced this provision in USMCA. It wasn't in the TPP. Tech lobbyists lobbied really hard for that provision, but it appeared in the USMCA. Now, like US is negotiating a free trade agreements with the UK, with Kenya, and also the WTO, World Trade Organization joint statement initiative on e-commerce. So they introduced that provision there too. And we are trying to figure out how to push back, because this will have implications. It will have implications for us and for other countries, and it will prevent governments to introduce any kind of liability provision in their own legal systems against tech companies. So I think the problem with most of these most of these provisions is they are trying to align the digital rules and regulations with those of the United States, and we have very limited number of rules and regulations on digital, and so preserve the status quo. And they also aim to introduce regulatory chill. Like if governments want to introduce rules, there will be like trade rules, like limiting their regulatory space. So from the consumer's perspective, there is, as I mentioned, it's all about our data. There are monopolies leveraging our data, collecting our data, processing our data, using our data, selling and sharing our data. But there's a growing consumer awareness, especially in the US and other countries. And we want, like as consumer advocates, we want businesses, especially the tech companies, to accept the fact that privacy and data protection is a basic business requirement for digital trade, because it's essential for building consumer trust online. So there should be a line drawn, but where the line will be drawn, that's not very clear, because we are pushing for regulations in legal systems, not only in the US, Europe, in other countries, but in the meantime, tech companies are pushing for these rules in trade agreements. And we need to be very careful about digital trade and these rules and pay attention to them. But in the meantime, we should also be demanding our digital rights, especially in the US, because the US is the problem. And last but not least, just to do all these things, like, you know, work on digital trade, and demand our digital rights, we created a small alliance with some of the consumer and digital rights groups, which is called Digital Trade Alliance. And we've been working really closely to push back on digital trade rules. And stay tuned for more actions, letters, and also webinars on digital trade rules and particulars of digital trade rules. Thank you very much.
Great. Thank you very much, Burcu. If you can end screen sharing. Perfect. Thank you. I found these presentations extremely helpful. And I already have a number of questions coming in. Folks, if you do have a question, please use that Q&A button at the bottom of your screen, and we'll get to as many as we can in our final 10 minutes. I guess the first question, I guess, is for you, Duncan. One question has to do with the impact of digital trade rules on teaching and public education. Obviously, with COVID-19, there's way more virtual education than there ever has been before. And there are concerns about the ways in which corporations are trying to use this to further privatize and chip away at public education. Can you just comment on how digital trade rules may affect this space?
Yeah, I mean, it's a really challenging question. So, but I mean, I've certainly felt the full force of the digitization that's going on in the school system. So I've got 3 kids of school age, and you know, we've spent the last 3 months getting to know Zoom, virtual teaching, various apps to communicate with teachers, and you know, and without a great understanding of where this data is flowing. And I think, you know, anything that has to do with the data of our children needs to be treated with even more extreme care than general personal data. So in Europe, we have specific protections for the under 13s. The under 13s are considered that that data should, in theory, not be processed and collected about them. And indeed, I'm launching about to launch a big class action lawsuit against one of the major platforms for taking our children's data without permission. So on the one scale, you know, you've got this natural digitization. You've got a much more harmful element as well, where, you know, schools in China and elsewhere are using algorithms that assess attentiveness of students, start to make some kind of capacity, and like whether, you know, all these kind of things, which are again much more worrying, but haven't yet at least filtered into the UK system. So I think it'd be a bit hard for me from a UK perspective to understand really the push against the public education system in the US. You know, in Europe and in the EU, you know, the private education system is such a small bit. Everybody is publicly educated, and so although the digitization is a concern, and what happens to the data about our children, and as AI systems move into the education system, we should certainly be vigilant. But yeah, it's hard to comment exactly on what the US impact on that would be. But I dare say, as with other sectors, it will be impacted.
Thank you very much. Another question we have is, do you find it strange that Trump is pushing for US ownership of TikTok, with a key justification for that being that Microsoft would store the data in the US, when at the same exact time, US Trade Representative is busy negotiating trade deals that disallow local data storage requirements? I don't know who wants to comment on that.
Okay, I'm going to jump in because I find it very interesting, because all those years, like we heard from like the trade representatives and trade negotiators, even big tech, like data should flow freely, like open networks. But you know, with the TikTok, we realized that data should flow freely only to the US. If it flows somewhere else, they're gonna stop it. So, I mean, there are many challenges related to China or data flowing to China, and privacy challenges, also government surveillance and everything. But I think it is very hypocrite of, like, you know, US trade representative and the US trade officials and US government to dictate like TikTok to sell TikTok America to Microsoft, because the thing is, we have the same problem in the US. We don't know what happens. And today, for instance, Secretary Pompeo announced the clean network to safeguard Americans' assets. It limits like all the Chinese influence over net, like, and it is very interesting because like we heard about open networks, like data flowing around the world, and now like we are acting like China. And they use the privacy. I mean, excuse is the privacy. If US cares that much about privacy, the US should introduce like meaningful and comprehensive privacy rules and data protection here in the US, because we have no protections. And we don't know what happens to our data. Are we safe in the US? We have no idea. I mean, we had like as consumer groups from both in the US and EU, we conducted some studies about the apps, like how they collect our data, how they process it, how they share it. It's crazy. It's crazy. Like, you know, once they have the data, they share it with like lots of advertisers, lots of other apps. So we should be really concerned about that before China, because it doesn't really sound right, like when we don't have any protections here in the US.
Amba, we're getting a number of questions. I'm trying to synthesize them. You know, about government surveillance of activists. I mean, certainly those who've been doing trade justice work for a long time are familiar with being spied upon. You know, WTO rounds around the world. You know, Black Lives Matter activists are increasingly seeing police departments rely on companies like Dataminer, pulling together, you know, intelligence reports on activist activities on social media. I guess one of the questions is just, you know, was broadly what should activists know about how algorithms and trade secrets fit into this type of surveillance? But then maybe the flip side of the same coin, are there examples you can think of where access to information about algorithms has been used to try to counter some of those surveillance programs?
Yeah, I think this is, to me, one of those examples which demonstrates that simply like asking for source code and getting access to not just source code, but also other technical features of the system is important, but it also is not a substitute for actually challenging the broader political processes that are at play. So for me, the answer here is much more in broader surveillance reform, which tries to create transparency around the users of these technologies. And I would say, like, taking the specific example of live facial recognition in public spaces, it's very clear that in the last year and a half, the main users of these systems has been to create watch lists of protesters at in public spaces. And so it seems to me that in most of the countries where this has happened, it would be a straightforward constitutional challenge to say this not only interferes with my right to privacy, but it has a chilling effect on my right to protest, my right to movement, my right to a public life. And so the response to the system to these actions from activists in the digital rights space has not been, can we know more about these systems? It's very clear what these systems are doing. So can we please ban them, particularly in public spaces? And the more strategic argument has been that if they are in public spaces, then it kind of goes against the criminal due process argument that not everyone should be made a suspect without due process or without any cause, without probable cause. And the fact that these systems are infiltrating public spaces makes it more likely. So that's taking the example of facial recognition, but the broad meta point I would say is that this is to me a place where the buck stops, and it's really not about, can we find out more technically about these systems?
No, thank you for that very much. We have a bunch of other great questions. Let me just ask one more, and then maybe some of these we can address over email and whatnot. But someone mentioned, Duncan, the Ford Motor Company just announced that it's developed robots that can carry packages from their self-driving vans and trucks to customers and businesses, so that people are basically taken out of the delivery equation. And the question is, obviously there's a concern about automation here for workers in these industries, but there's got to be some jobs involved with self-driving cars, with robots that carry packages, with drones, etc. could you talk a little bit about what those jobs might be and how digital trade rules could affect where those jobs are located?
Yeah, so I mean, we've just done a project here in the UK looking at the bus sector, which is also looking to kind of automate. And what's interesting about when we looked at the kind of the bus sector was that initially the first few levels of and you know, we also need to remember that we are a long way from fully driverless cars delivering packages en masse. And in fact, we may not ever get there. Like the complexities of actually putting these real world systems in, you know, if we talked 5 years ago, we were going to be 5 years from seeing it happen. If we talk now, we're still 5 years. You know, it's going to be that last 10% to make these things safe and on the roads or properly autonomously is hugely challenging. And for the moment, nobody has really demonstrated it successfully. Now, notwithstanding that caveat, many people are trying, and chances are is that we will ultimately get there. And we will only get there off the backs of workers today providing the data for their future unemployment being harnessed by the company. And so the companies most likely to be able to do this are those that are able to aggregate the biggest amounts of data, both you can think nationally, but also this is going to be an international concern. And so the kind of jobs that you'll start to see, so these vehicles will probably require more repair. That's what we saw in the bus sector. They'll be more complex because they'll be less mechanical, much more electrical. You know, the car has already become so complicated to repair compared to 30 years ago. You now need a diagnostics box and some expertise in computers really to fix a car, rather than before where it was all about your pistons. I mean, I don't even have a driving license. I'm way outside my expertise here. But so you'll see jobs there. You will see certainly jobs in terms of designing the systems. Certainly for the bus sector, you will have kind of central control nodes, because ultimately these things will fail in the real world, and people will actually have to take over them, not in the vehicle, but from kind of centralized command posts. So you'll see all these kind of, but what you won't see is a replacement of a mass market decent job with another mass market decent job. You will see thousands of jobs replaced by 1 or 2 jobs, and at the skill levels. So when we looked at the bus sector, the bus companies are very concerned about whether we train up the bus drivers to take on some of these new roles in the new kind of automated bus world. And there's definitely a lot of concern there. But so I think definitely this notion of full automation I see is still a long way off. And the interim levels of automation actually offer the chance of actually more employment, both in terms of vehicle surveillance. So cars will need these delivery vehicles will need a person at the wheel, even if they're not physically driving for quite a while, just because of legal requirements around liability, how insurance companies work. So in the bus sector, where we've started to see the beginnings of automation, we've actually seen increased employment in bus companies rather than a decrease. But the long-term trends are what are really kind of worrying out there.
All right, thank you very much. I want to thank our presenters one more time for their excellent presentations. We will circulate the link to the video to everyone, encourage you to share it. And if you have other questions, you can email me at arthur@tradejusticeedfund.org, and I will endeavor my best to get your questions answered. And we really appreciate everyone's time. Have a great day, everyone.
Thanks for hosting. Cheers, bye.
Thank you.